The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Lies, lawyers, and Larry King. The heat gets cranked up just a notch. Hello, I'm James Curtis, and welcome to E's exclusive coverage of the Michael Jackson trial. When he arrived, the King of Pop flashed a peace sign to some anti-war protesters, and that was just before or as he entered the courthouse to hear yet another day of testimony, and testimony in a trial that certainly will, no matter what the outcome, change his life. On the stand, Larry Feldman. Now, he's the lawyer. You've heard that name often. He brokered the reported multi-million-dollar settlement against Michael Jackson back in 1993 for another young accuser. Under questioning by the district attorney, Tom Sneddon, Feldman tells the jury about his earlier client. Here's what the jury heard according to the courtroom transcripts.
Let's turn to a specific case if we can, and I'd like to focus your attention to the year 1993 and 94 if we can. Are you familiar with a then young boy by the name of Jordan?
I am.
And how did you become involved? By the way, did you know when you first met Jordan, do you recall how old he was?
He was 13, as I recall.
And as a result of the interviews and what other actions you also took, did you eventually end up filing a lawsuit against the defendant in this case, Michael Jackson?
I did.
On behalf of Jordan?
I did file a lawsuit.
And with regard to the causes of action, what was the nature of the causes of action alleged against the defendant, Mr. Jackson?
The sexual molestation of Jordy.
Now, did that particular case, the case of versus Jackson, eventually result in a settlement?
There was.
And now, as a result of that first conversation with family, did you decide to take a form of a course of action of any kind?
Well, sure, of some kind.
All right.
I mean,
what would you categorize in terms of the way you handle cases as the process that you felt was going on at this point?
The process that I follow in my law office at all times is people come in, they tell the factual story. We then, depends on the case, but generally speaking, we then will do research, legal research, especially in a case like this, to see and try to understand what the law is. And because of the nature of the potential defendants at that time, which was ABC, this Martin Bashir, whatever his company was called, it involved Michael Jackson. We were going to make sure we knew what we were doing before we started. And so after we sort of heard this version of the facts, of some facts anyway, that's the next step that we did.
And after speaking with the family, Feldman suggests that they meet with clinical psychologist Dr. Stan Katz. Now, you remember you heard his testimony last week. Here's what happened next.
And as a result of those conversations with Dr. Katz, did you decide on a further course of conduct that you felt needed to be done?
Objection, leading.
Overruled.
Yes.
You may answer.
What did you do?
I then believed that Dr. Katz believed he had a report, and I then went to the head of...
Objection, move to strike, hearsay.
His belief is stricken. The question is, what did you do?
I went to the head of the Department of Children's Services, Los Angeles County, a fellow by the name of David Saunders, who was the head of the Department of Children and Family Services.
And was this the purpose for the three of you going down to the L.A. department?
The purpose was for him to report, but he could have done it on a hotline like was done in '93. This time it was to have it guaranteed it was never going to leak out to the press.
Okay. Now, as a result of this conversation, were you directed to another agency?
Well, he directed me into a room with two people. That's where he directed me.
You had a conversation with those people?
I had a conversation with those people.
And as a result of that conversation, were you directed to another agency? Let me put it this way. Did they take the report?
They didn't take the report, and they didn't direct us to another agency.
Now, that seems to be instructive. Hello, everybody. Good to see you after the nice long weekend that we had. Not extraordinarily long, but at any rate, Howard, the idea that, let's deal with something very, very preliminary. Howard, the idea of attorneys testifying in trials. This is the second attorney in this case. That's not a very ordinary occurrence, especially in a criminal trial, is it?
No, I think it's very unusual. To me, it's clear that Mr. Feldman does not want to be there, does not think he should be there. As I've said before, I believe the judge erred in allowing this testimony in.
Ricky, why is he there?
Well, he's there because one of the defense lines of attack is that this is all about getting money. And the way the defense says it's about getting money is that of all the lawyers in all the world to be the repository of this family, it's Larry Feldman who had the first case against Michael Jackson in '93.
I'm sorry, he's also there to get in the settlement. The judge ruled that the settlement can come into evidence, not the amount, but the fact of the settlement itself, and Larry Feldman brokered that deal, and so he's there to get that in as well.
But he's subpoenaed by the district attorney's office. I don't believe for a minute Larry Feldman would have called Tom Sneddon up and volunteered to come in there and testify about this.
Why?
Because the settlement was confidential. The settlement is not admission of guilt. And Larry Feldman's a pretty experienced lawyer. There's no reason in the world for him to want to be there. He got subpoenaed, and he showed up, and he did what he was supposed to do.
You know, one of the problems with cases like this, and Mr. Feldman is just the man in the middle, is that when lawyers get to use their clients, to get a deal for their client's benefit, Howard and Johnny Cochran on one side of that deal, Mr. Feldman on the other, part of the purpose of the deal is confidentiality. No one is going to know about this. When these explode by virtue of a subpoena 10 years later, it is not good for other lawyers for future clients.
And we're going to explore that much more as we continue to hear more from Larry Feldman. He calls someone we all come to know.
Now, after you left the agency, did you decide on a course of action?
Yes.
And was this regarding and connected with Dr. Katz's responsibility as a mandated reporter?
Yes, because I felt he still hadn't reported because they didn't take the report.
Objection. Objection. Move to strike. Non-responsive.
After yes is stricken.
All right. Who did you call?
I called you.
Okay. And as a result of that conversation, were you eventually contacted by somebody else?
My recollection is that I was contacted by a police officer, or he may have been a sheriff. I don't know what he was, but he was some law enforcement person.
Now, during the course of the conversation between you and I, did the subject of a civil lawsuit against Michael Jackson in connection with the substance of the mandated report come up?
Yes.
Objection. Leading.
Overruled. The answer was yes.
And in that connection, was there a representation made by you to me concerning a civil lawsuit?
Yes.
Objection. Leading.
Overruled. The answer was yes.
And with regard to that representation, and Your Honor, I'm offering this under 1250, what was said by you to me?
No lawsuit. I would not file a lawsuit. There was no plans to file a lawsuit, and that you would investigate it and make up your own mind. Not you, but the police.
Investigate it and make up your own mind. I don't know. It just sounds, and we're not hearing the actual words, even though these are the actual transcripted words. We're not hearing it from Feldman's mouth. It's not convincing me. I'm not really going with it, Howard, that they were going to let the district attorney make up his own mind.
Well, look, it's interesting. Mr. Sneddon, we know, had a vendetta, I believe, against Michael Jackson.
Right. And a lot of people subscribe to that, that theory.
Mr. Feldman contacted Mr. Sneddon after L.A. County would make a report. He clearly believes Michael Jackson has done inappropriate things in the past. What I do think is fascinating is Mr. Feldman wouldn't pursue the civil remedy first. He listened to these people, he took them to L.A. County, and then he gave them over to the district attorney's office. I found that unusual, and perhaps he didn't have the same strength and conviction about this family that he did about the family 12 years ago.
Go ahead.
You let the government do its thing.
I don't know. I think that Mr. Sneddon knows that the filing of a civil lawsuit, or even the threat of the filing of a civil lawsuit, is going to destroy the criminal case, because that's going to be the motivation. I don't think the jury is going to believe that there's not going to be a civil lawsuit filed, but I think at this point in the proceedings, as Sneddon and Feldman are talking, they both know that if a civil lawsuit is filed or it's even discussed, that's going to have a very negative impact on the criminal prosecution.
And there brings in, with that kind of issue, we have the specter of the Kobe Bryant case, the civil lawsuit that apparently destroyed that criminal prosecution.
And the 93 case here.
And the 93 case here. And we'll talk about that a lot more in just a little while. Still ahead, Tom Mesereau can't believe his ears. He's not the only one. And what in the heck does Larry King have to do with this case anyway? Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. You've got to be kidding me. No, that's not just me getting excited yet again. I do that a lot, don't I? Well, it seems that that's also Tom Mesereau's reaction to testimony about not suing Michael Jackson civilly. Here's what the jurors heard according to the courtroom transcripts.
Mr. Feldman, if Gavin decided at some point in the future to sue Mr. Jackson for alleged sexual abuse, how much time would he have to file that action?
I think he'd have till his 20th birthday.
If Starr decided in the future to sue Mr. Jackson for alleged sexual abuse, how much time would he have to file that lawsuit?
I think the answer is the same, 20.
If at the end of this trial they were to decide, you know, we'd like to sue, they'd have plenty of time to do it, wouldn't they?
They meaning the boy?
Gavin.
Not Janet.
Gavin and Starr.
The two boys.
Yes.
If they wanted to at the end of the trial, they could sue, sure.
Isn't it true that a judgment of conviction in a criminal case for anything related to child molestation could be dispositive in a parallel civil suit alleged for the same facts?
As long as it's a felony conviction, that's right.
In other words, if Mr. Jackson were convicted of felony child molestation in this case, either Gavin or Starr could use that conviction to essentially win a civil case regarding similar alleged facts against Mr. Jackson.
That's correct.
Oh, he didn't want to give that up, did he? Next, could there be an even bigger pot of gold at the end of the litigation rainbow?
Mr. Feldman, you've testified that you had filed as a lawyer for a notice of claim against Los Angeles County, correct?
Correct.
And the purpose of filing that notice of claim was to preserve the right to sue in the future if you desire to, correct?
Correct.
And you told the jury that at this point, in your opinion, Gavin and Starr still have time to file a lawsuit against Los Angeles County, correct?
I believe that's right.
The lawsuit you're referring to, if it ever occurred, would be separate and apart, or could be separate and apart from any lawsuit against Mr. Jackson in the future. True?
I think it would have to be separate and apart. I don't think you could join the two, but it would be. I think the simple answer is yes.
And as we speak then, those two young men still have a right to sue Mr. Jackson, and they still have a right to sue Los Angeles County in a separate action. True?
True.
Howard, this is just your day-to-day. I mean, not only do you know Feldman, and you've known him for quite some time, know him well, you represented, along with the Johnny Cochran firm, Johnny himself, Michael Jackson in the 1993 case. What are you taking away from all of this?
Well, I'm taking away that this cross-examination of Mr. Feldman leads up to the fact that these people can file a lawsuit if there's a conviction here and prevail. I think, however, Mr. Mesereau's cross-examination gives the jury pause as to whether or not they want to accept the credibility of this witness. It's very good cross-examination.
Is it working?
It's really a classic. I think that Tom Mesereau, as I often say, is one of the great cross-examiners.
And he's doing an outstanding job here.
This is just classic, textbook, perfect. Yeah. Really what he's saying are simple facts. You already preserved the right to sue the County of Los Angeles, so we know you've at least thought about that. And you say you're not going to sue. You have no plans of suing. You never have even thought about suing Michael Jackson. But after all, they have till they're 20. And wouldn't it be great if they got a conviction here? Because then it's all done for you. It's a classic cross, and Larry Feldman has to say yes.
Yeah. And it's interesting to me that L.A. County didn't do anything which forms the basis for this claim against L.A. County. Because you have to presume that L.A. County is impartial. They investigated this case and decided not to do anything about it. Santa Maria, and Tom Sneddon, on the other hand, not so impartial, had a completely different approach.
That's at least the argument.
Yes.
Right. And that's going to be something that I don't think will be lost on these jurors. What does it mean that an agency not affiliated with this county, the county where this prosecution has taken place, decided they weren't going to pursue? Indeed, there was no wrongdoing found. Then all of a sudden,
it's just not substantiated. It's more complicated than that there was no wrongdoing found.
Well, it wasn't substantiated. The claim of wrongdoing was not substantiated. Okay. Ricky always saves me. Defense attorney Mesereau drives home the point. In a civil lawsuit, the poor might profit, but the rich would certainly get richer.
Now, in Los Angeles County, you're known as one of the most successful plaintiff's lawyers, correct?
Say it again for the press. I want to That's the nicest thing anybody said about me in this case.
Is that true?
I think so.
You've had numerous multi-million-dollar awards that you have obtained for your clients, correct?
I have.
You have numerous multi-million-dollar settlements you've obtained for your clients, correct?
I have.
And in most of those situations, you had what is called a contingency fee arrangement, correct?
Oh, I'm sure. Yeah. Over the life of my legal career, that's absolutely right.
And generally speaking, in a contingency fee arrangement, the plaintiff's lawyer in these cases, namely you, get a percentage of whatever is recovered for the client, true?
Yes.
And in a strict contingency fee arrangement, if the lawyer doesn't obtain any money for the client, the lawyer might not get paid anything, correct?
Correct.
So there's an incentive for that lawyer to get as big a recovery as possible, because the bigger the recovery for the client, the bigger the fee for the lawyer, correct?
That's the theory.
Now, a shocking charge from Tom Mesereau.
Mr. Feldman, do you remember telling two individuals, Michael Viner and Larry King, that Janet is making up these allegations?
Absolutely not. Are you kidding?
Do you remember meeting with those two individuals at the Grill in Beverly Hills?
No. Never met with him.
Do you know who Michael Viner is?
I couldn't pick him out. I know who he is. I think the answer is I wouldn't know him if he was sitting in the jury box, but I know who he is by name. He's a publisher or something, or writer, or I don't know. Viner Books, right? Something like that. I certainly know who Larry King is.
You did have a meeting with him and Larry King, right?
I have never had a meeting with Michael Viner in my life.
So approximately 9 months ago, you didn't meet with Mr. King and Mr. Viner, correct?
I absolutely have never had a meeting with Michael Viner in my life.
Okay, and did you ever tell Larry King that these allegations against Mr. Jackson are false?
Absolutely not.
Little fiery there. Ricky Kleeman, let's try to clear something up and kind of get this thing laid out. First of all, in California, there are two charging documents. There's two phases or stages that things go through. There's a complaint initially, and then when the facts get refined, there's an indictment or an information.
Okay, and what we have here is the complaint really stretches the days, because
Yes.
it brings us all the way back to February 7th and then into March 10th. But the indictment, which is based on what the grand jury hears, it's what these kids told the grand jurors, it brings it all the way down to February 20th. That's 2 weeks later. So getting back to the Los Angeles County, probably when Los Angeles County talked to these kids, there was no allegation of molestation for the grand jury. There may have been for the complaint.
There may have been for the complaint, and that was probably the basis of going to L.A. County in the first place, those first set of dates, but they changed. Do facts change? We'll discover that and discuss that a little bit more. When we return, Larry King Revisited. We promise you a celebrity a day, only on ETV, and we deliver. Be right back.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Fired up and firing back, District Attorney Tom Sneddon jumps into the suddenly volatile Larry King debate. Here's what the jurors heard according to the courtroom transcripts.
Now, you were asked by, just before Mr. Mesereau finished his examination, about a purported conversation between you and Mr. King and Mr. Viner, or Viner?
Viner.
Viner?
Viner is what he said.
Yes, and do you recall any such meeting?
I never met with Mr. Viner. I did once meet with Mr. King. I do remember meeting with Mr. King, but I can tell you there wasn't a meeting with Viner.
Were there other people present?
Well, we were in the delicatessen in Beverly Hills, so there were a lot of other people around.
By Mr. King, you're talking about Larry King.
Right.
The guys on...
We say hello to each other, we see each other, talk to each other, never having talked about this case, and they did want me to come on their program. I mean, I do remember them talking to me about that. But I can tell you that I didn't tell them, and I didn't tell anybody else, anything about what anybody tells me because it is absolutely privileged, and it would be absolutely improper. If anybody says that, that person is lying. Can't make it any clearer than that.
Well, Sean Chapman-Holly, it's privileged unless there are others present who also overhear the information, then no privilege.
Right, and it's unclear, I guess, whether or not this Mr. Viner was there. That's going to be critical. We're going to see whether or not Mr. Mesereau can deliver on this. It's interesting, though, you spoke a while ago about these jurors in Santa Maria and whether or not they're going to be take a negative away from celebrities coming into this case. And you have to wonder whether or not they're looking at this Mr. Feldman, this fancy attorney, you know, having lunch with Larry King at the Grill in Beverly Hills, and whether or not, you know, they're kind of looking down at this whole thing. And I'm pretty sure that they don't believe that he doesn't have a lawsuit coming down the path.
And whether they believe it or not, though, it really doesn't matter, does it, Ricky? Because the idea, as Snedden, as Mesereau skillfully pointed out, whether you got to file now or not, it doesn't really matter because you can always file it later.
You can always file it later, which is Mr. Mesereau's point. And, of course, all of us know who have dealt with these cases is that every prosecutor in America who knows there's a potential for a civil suit doesn't want it filed until the trial is over so that the witness can't look like the witness is biased.
Ask Mark Hurlburt in Denver his undoing. Howard, final thought?
Well, I hope Tom Mesereau produces Larry King because basically he's called Larry Feldman a liar, which I personally find hard to believe that Mr. Feldman would lie under oath as he did in this case. So unless he has Larry King coming in to say, Mr. Feldman told me that he didn't believe these kids or that there wasn't a case, from my perspective, that probably wasn't the best question to ask.
Yeah, but come on, Sean. Mesereau's not going to ask a question like that unless he's got some ammo.
Yeah, he's got to have some ammo. It's going to be very interesting to see what develops here because it's critical at this point.
Indeed it is, and one would hope that Mr. Mesereau would have an affidavit or something signed or a recording or something.
All right, we're going to have to leave it right there. That's it for us for today, but be sure to watch our exclusive Michael Jackson trial coverage Monday through Friday, 7:30 p.m. That's a new time, folks, 7:30, and for a preview, a sneak peek, if you will, of tomorrow's reenactments, check it out, eonline.com.
Go ahead.